You're wondering if you really need a lawyer, or if you can just handle this yourself and save the money. That's a fair question, and the insurance company is hoping that you decide to go it alone. Here's what 27 years of fighting for injured Iowans have taught me. There are specific warning signs that tell you exactly when you've crossed the line from "I can handle this myself" to "I'm about to get taken advantage of." I'm attorney Tim Summelroth of RSH Legal. If you or someone you love has been injured and wants a free case strategy session with a lawyer you can trust, call us today at 319-895-1847. In this video, I'm going to walk you through 7 signs that tell you it's time to get professional help before the insurance company's tactics cost you thousands. Sign number 1, the insurance company is rushing you to settle. When an insurance company calls you quickly with a settlement offer in a friendly voice, that's not generosity, that's strategy. Here's what they're counting on. You don't know yet how badly you're hurt. You don't know what your claim is actually worth, and you're stressed, you're in pain, and a check just sounds like relief. But that first offer, it's almost always the lowest number that they think you'll accept. And the moment that you sign or e-sign that release, you're done. If your injuries get worse, if you need surgery, if you can't go back to work, too bad. That door is closed forever. And here's the trap that most people never see coming. If your health insurance paid any of your medical bills after the accident, they may have a legal right to be repaid from your settlement. It's called subrogation. I've seen people accept what sounds like a $40,000 settlement only to discover that they owe $30,000 back to their health insurer, leaving them with almost nothing for their pain, lost wages, and future medical needs. An attorney calculates these numbers before you sign anything so that you can know exactly what you're keeping. It gets worse. Some adjusters will deliberately delay responses or deny valid claims just to wear you down, hoping frustration pushes you into taking less. When you see any of these pressure tactics, it's your first sign that you need a lawyer in your corner. Sign number 2, your injuries are serious or you've hit $5,000 or more in medical bills. A minor fender bender with a sore neck that clears up in a week, you might be fine on your own. But the moment that your injuries go beyond that, broken bones, head trauma, a herniated disc, anything requiring surgery or ongoing therapy, the stakes change dramatically. Here's the threshold that I've been telling people after 27 years of handling these cases. If you have racked up $5,000 or more in medical expenses, you should absolutely be talking to an attorney. If you've had surgery or been told that you will need surgery, if a doctor says you'll need ongoing treatment, if you've sustained any permanent injury or disability, if your injuries keep you out of work for an extended period of time, these are all signs that you need professional help. Here's what insurance companies don't want you to understand. The true cost of a serious injury isn't just your current medical bill, it's the future surgeries, the physical therapy for months or years, the wages that you lose while you recover, the pain and emotional distress that doesn't show up on an x-ray. Insurance adjusters are trained to downplay every one of those costs. They'll minimize your future medical needs and ignore your suffering entirely unless someone with legal expertise forces them to account for it. Sign number 3. Fault is unclear or it's being disputed. Here's where claims get dangerous fast. When the other driver blames you, when there are multiple vehicles involved, or when the police report doesn't tell the first story, an insurance company sees an opening. Their favorite move? Claiming that you were partially at fault. Iowa is a comparative fault state, which means that if they can pin even a percentage of blame on you, your compensation drops by that amount, and they will try. But here's the number that should scare you: 51%. Under Iowa law, if the insurance company can pin more than 50% of the fault for the crash on you, you don't just get a reduced settlement, you get nothing, zero. It doesn't matter how badly you were hurt or how much the other driver contributed to the crash. Hit that 51% threshold and you recover nothing at all. That's why the insurance companies fight so hard to shift blame. Every percentage point they can put on you is money they don't have to pay. So conflicting witness statements, unclear unclear intersection footage, disputed traffic signals, all of that creates chaos that benefits the insurance company, not you. They have investigators and adjusters piecing together a version of events that protects their bottom line. You need someone building your story backed by evidence, witnesses, and legal knowledge. If fault is being questioned at all, that is a glaring sign that you cannot afford to navigate this alone. Sign number 4, they're asking for a recorded statement. Here's something that may shock you. That friendly insurance adjuster who calls just for a quick statement has actually been trained to use your words against you as weapons. You might think that giving a recorded statement shows that you have nothing to hide. The reality, these recordings are analyzed word by word for inconsistencies that can be used against you, even slight variations in how you describe the accident days apart. Here's what they don't want you to know. You are under no legal obligation to give a recorded statement. Refusing will not reduce your compensation by 1 penny. In fact, it can protect your claim from being undermined before it even begins. They'll ask innocent-sounding questions designed to trap you. How are you feeling today? If you say fine just to be polite, they'll use that recording to claim that you're not really injured. Exactly how did the accident happen? One small mistake on your part in describing the sequence of events, and they'll claim that you're lying or confused. If an insurance company is pushing for a recorded statement, that can be a major red flag. At our firm, we only allow our clients to speak to adjusters when one of our attorneys is present to protect them. Sign number 5, you have a pre-existing condition that they can exploit. This might be one of the most misunderstood areas of personal injury law, and it's where insurance companies can pull their dirtiest tricks. If you had any prior injury or treatment to the same area of your body that got hurt in this crash, prepare yourself. The insurance company will try to use it against you. They'll argue that your pain is old news. They'll claim that the crash didn't cause your current problems. It just brought attention to an injury that was already there. They'll try to reduce your settlement to almost nothing by saying you can't prove that the accident made anything worse. But here's what the law actually says. You're entitled to compensation for the aggravation or worsening of a pre-existing condition. So if your job was manageable with your prior occasional back pain before the crash, but now you can't work at all, that difference matters legally. And the insurance company's playbook is predictable. They'll demand all your old medical records. They'll hire doctors to say that your problems are age-related. They'll argue that any treatment that you need was going to happen anyway. This is why documentation is absolutely critical, and why you need someone who knows how to prove the crash made your condition worse. Don't let them use your medical history to cheat you out of fair compensation. Sign number 6, a government vehicle was involved. Here's something that many people never learn until it's too late. If a city vehicle, a county vehicle, a state vehicle, or any other government-owned vehicle was involved in your crash, the rules may change dramatically. Instead of the standard 2-year deadline to file a claim, you may have just 6 months to file a notice. Not 2 years, 6 months. This shortened timeline catches people off guard all the time. They think that they have plenty of time to figure things out, get medical treatment, decide whether to hire a lawyer. But while they're waiting, the deadline passes, and suddenly they have no case at all, no matter how seriously they were injured. The insurance company won't remind you. The government agency won't warn you. The clock just keeps ticking. If any government entity was involved in your accident, you need to talk to an attorney immediately. Not next month, not after you're done treating, now. Sign number 7, the insurance company won't cooperate, or your own insurance company is involved. When the insurance company stops returning calls, delays payments, or flat out refuses to negotiate fairly, they're betting you'll give up. They're betting you don't have the resources or the energy to fight back. Here's a situation that surprises a lot of people. Sometimes the biggest threat to getting fair compensation comes from your own insurance company. This happens when the at-fault driver has no insurance or doesn't have enough insurance to cover all of your losses. Right now in Iowa, drivers are only required to carry $20,000 in liability insurance. What happens if your medical bills alone are $50,000? Your only chance for fair compensation then comes from your own uninsured or underinsured motorist coverage. But here's what's truly alarming. Even the possibility that you might make a claim under your own auto policy causes your insurance company to go into pay as little little as possible mode. Your own insurance representatives are trained to use the same tactics to reduce claim payouts, even when you're their own customer who's been paying premiums for years. They'll pressure you for recorded statements, demand broad medical releases, and make lowball settlement offers, just like the other driver's insurance would. That's why you can't assume that your own insurance company is looking out for your best interests. They're a business focused on profits, not a friend looking out for your well-being. Now, you may be asking yourself, why don't insurance companies want me to talk to a lawyer? Insurance representatives will often tell you that you don't need a lawyer because we can just work this out on our own. But here's what they're not telling you. There is no we in this situation. Want proof? Internal insurance industry documents have revealed that some companies train employees to discourage accident victims from hiring attorneys. They even give bonuses and raises to adjusters who can consistently talk people out of getting a lawyer. Why are they so desperate to keep you from getting legal help? Because insurance industry statistics show that represented claims settle for 2 to 3 times more than unrepresented claims. Now, that's not my opinion. That is information from Allstate's own training manual, which was discovered during a lawsuit. After 27 years, I can tell you this: insurance companies treat unrepresented claimants and represented claimants very differently. So which side do you want to be on? You may be hesitating to call a lawyer because you're worried about the cost. And here's something that the insurance companies hope that you never find out. Most personal injury attorneys, our firm included, work on what's called a contingency fee. That means you pay nothing up front, zero. We only get paid if we win your case. If we don't recover money for you, you owe us nothing for attorney's fees. We also advance the costs of building your case, hiring the experts, gathering medical records, everything needed to fight for you. You only pay those costs back if we win. That's exactly why insurance companies try so hard to discourage you from calling a lawyer. They know that you can afford representation, and they know what happens to their settlement offers when you have it. What if you've already talked to the insurance company? Is it too late? It's not too late, but don't say anything else until you've talked to an attorney. Yes, early statements can complicate your case, but an experienced lawyer knows how to work around them. We can gather additional evidence, provide context, and build a case that addresses whatever you may have said. The worst thing you can do now is keep talking to them alone. Every additional conversation is another chance for the insurance companies to find something to use against you. Let me be direct with you. If the insurance company is pressuring you to settle fast, if your injuries are serious, or if your medical bills are climbing, if fault is being disputed, if they're pushing you for recorded statements, or if you have a pre-existing medical condition that they can exploit, if the government vehicle was involved, or the other side simply won't pay fair, these aren't just warning signs. These are alarms. Recovering from an accident is hard enough without fighting a billion-dollar industry by yourself. You deserve someone in your corner who's done this before and knows how to win. If you or a loved one have been injured here in Iowa and would like to set up a free case strategy session with an experienced attorney who will fight for what you deserve, please call us today at 319-895-1847. Our conversation is confidential. It costs you nothing, and it can potentially get you the biggest settlement possible for your case. If you found this video helpful, subscribe to this channel and make sure you watch this next video.